Okay, everyone, this is Joe Esquivel, and I'm with Mortgage Compliance Investigators. I'm here today. We're doing a webinar. We're going to be going over our new product. The new product is a combination of the chain of title analysis and mortgage fraud investigation, which were two separate products. I created the chain of title analysis a few years ago, and we have been like a chameleon, changing as the industry changes. Our arguments have been the same. I've had the same arguments that I've had in 09. The only difference is I've got my arguments refined. My arguments are laser bullet points. And there's a reason for this. When we first started out, we were learning how to walk. Then we learned how we could start jogging. And today we are running towards the goalpost. So what this product does is it gives you a comprehensive education as to what is going on to your specific loan. So if we get started, you're going to see this is a cover page. All right, and this is an actual report that was done. The only thing that's changed are the names and the addresses. Everything else, the arguments and everything have been left the same. The names have been redacted and changed to John Doe. First thing you're going to notice is table of contents. Now, in this table of contents, we have sections that are broken up. Section 1 is intro to the conveyance of a securitized mortgage loan. Section 2 is the mortgage loan transaction history. Section 3 is the MCI infographics and mortgage fraud investigation. Section 4 is the educational material, and Section 5 is supporting documents. Now, what makes this product different is the specificity that we go into. When we're talking about a particular item as it relates to a securitized mortgage loan instrument, we need to pay close attention as to what has happened. So one of the things that I've done is we've put together basic definitions, so everyone is on the same page. When you're talking about a promissory note being tangible, I'm talking about something that is touchable, that's in tangible form. So I've given definitions so that you understand while you're reading the analysis or the rest of the educational material as to what we are talking about. So this in itself, the educational material, is invaluable. No one else has gone through and has provided you with the information that you will need as to make a determination to what is going on within your specific property. So these definitions speak specifically about the E-note, the security interest. We're talking about the security instrument being a tangible. When you have an understanding as you're going through this, it will allow you to actually have an understanding what happened, what did not happen, what really got securitized. Did anything get securitized? Because many times the claims that are presented are they're just hearsay claims. No one has come forth claiming to be Pete, person entitled to enforce. They claim they've acquired rights, but they have not. So what we've gone through and broken this down to its minute details. How are you going to use this? You are going to use this educational piece to educate yourself. When you understand educationally wise what happened, what did not happen, it allows you to have an understanding that attorneys do not have. When we're talking about conveyances, we start talking a little bit about MERS. We go into a little bit of detail, enough so you have an understanding. However, in order to have a full understanding of all of this, I would suggest that one would show up to our online training courses that we will be having in the month of January. We're going to be starting. So again, the whole purpose of the educational piece was to give you a view from 30,000 feet so that when you're looking at your documents and you're reading this, we took the time to break this down to as small, as detailed as we could get. Now, mind you, I can still go down this rabbit hole even deeper. But for the attorneys or for the pro se litigants, this will put you inside the rabbit hole, which will level the playing field. The rules have always been there. The difference is nobody's ever held anyone accountable. So in writing this, we had to have an understanding. Are we talking about the negotiable instrument pertaining to UCC Article 3? Are we talking about the security interest pertaining to UCC Article 9? Are we talking about a transferable record? Because when you articulate your arguments, you're going to be arguing many different laws at the same time. You're going to be arguing many different forms of arguments. You're going to argue for the tangible promissory note. You're going to argue for the general and tangible obligation. And you're going to argue for the security instrument. So one is going to be UCC Article 3. One will be Article 9. And the other will attain to local laws of jurisdiction. And when you argue them in parallel at the same time, you will stand a much better chance rather than trying to focus your argument on just the note, on just the deed of trust or the mortgage or just the obligation, the payment intangible. So the whole purpose of putting this together was to give you a breakdown. So when you looked at it, all right, the first 8 pages going into depth explaining the components for the transactions to take place. The whole purpose is for either the attorney or for the homeowner to gain an understanding what was taking place, who were the parties, what were the transactions. So if we had MERS on your particular transaction, we would include MERS. They would be in the section 2. All right, if you had Fannie Mae or Freddie Mac, or you did not have Fannie Mae or Freddie Mac, you either would or would not be on this part of the educational package. Any information that I find, you will get back. If I get a circular supplement, you will get it. If I have a 424B5 prospectus supplement, that will be included. If I can get the pool and servicing agreement, that will be included. If you have a trust agreement, if you're with Fannie Mae or a trust supplement with Fannie Mae or Freddie Mac. So the purpose of me giving you all of this information is so that you are the expert. I already have an understanding of what happened. So my job is to educate you as to what happened. These are screenshots that will be presented, again, depending on if you are with an RMBS, if you're with the GSE. This gives you information for your specific loan instrument. This particular one was with Fannie Mae 2007-029. All right. They were in tranche Z. So depending what your group you're with, they were also with collateral group 1. So depending where your loan is located or an interest of your loan, because you're not going to find your entire mortgage loan instrument. Every package will be complete with an infographic if it is possible. And I know there have been a few parties out there that say, Joe, why didn't I get an infographic before? Well, I only do them if I can. There are some instances where it's too complex, and unless somebody wants to pay me $250 an hour to sit down for anywhere from 5 to 6 hours to create one, then I would do it. So right now, I've got about 30 different infographics. So for the most part, if you are with an RMBS or a GSE, an RMBS being a residential mortgage-backed security, or if you're with either Fannie Mae, Freddie Mac, or Ginnie Mae, I will be able to get you an infographic that corresponds with your particular property loan at that instant. If you are with a private trust, the odds are that I will not do an infographic, simply because, again, the time and effort that is involved is a lot. I've spent countless hours putting these together, countless hours. And again, if you want to pay me, it will probably cost about minimum $1,000 to $2,000 to do a chart if I do one from scratch. So right now we are including them in the package, the competent evidence package. And how you're going to use it is that it is a visual representation. And what I mean by that is visually, you are going to be able to follow what happened. Within the analysis, I write in legalese. And many times people complain that they do not have an understanding and they cannot comprehend what I'm trying to explain. So these charts I've created expressly for the analysis. Because I could not find any other charts out there, these were created from scratch. So there is no other company with these charts. These are mortgage compliance investigator charts. We've researched it, we have created it, and this is the only place you're going to get them. So the whole purpose, again, is to provide you with an understanding so that when you are talking about your case at this instant, you are the expert. Whether you are an attorney or whether you are a homeowner pro se litigant, you are the experts. So if you happen to come to the same conclusions that I come to by looking at an analysis that I've gone through and created, and by looking at the statutes which are presented to you and the arguments that are presented to you, and whatever determination that you've come through, you make. You put it in the four corners of your pleadings. That is not Joe's opinion. That would be your opinion. Within the analysis, I give you my opinion, my conclusions, my arguments as an educational piece to educate you as to what was to happen, what did happen, what did not happen, according to state statutory requirements of law. If you happen to look at the pool and servicing agreement and come to the same conclusion that I have, then you will have learned something and you will be the expert. You will have firsthand knowledge. What was to happen? What was negotiation, transfer, and delivery for my particular loan at this instance? That is the whole purpose. When you understand, for instance, on this infographic, we have the borrower, John Doe. He has a note. He has a security instrument. In this particular instance, he's in a non-judicial state. MERS is named as a beneficiary nominee of record. Okay? After signing, the security instrument goes to the county recorder's office, where it is filed, indexed, and recorded. It then goes back to the original lender. Many times this lender will sell this instrument, being the note and the security instrument being a deed of trust or mortgage, to an originator. When the originator gets it, within 24 to 48 hours, the paper note is scanned into a system. It's then stamped with a payee as of yet unnamed, and then they deliver the paper tangible documents to a warehouse where they're either stored or destroyed. Shortly after that happens, they sell the intangible obligation. This is the value. This is the piece that gives value to the note. The note evidences the obligation. However, when they strip this out, and it's legal, it can be done at any time. Imagine that you had a strip shopping center. And within the strip shopping center, you had 10 stores. And you have leases on these 10 stores, and you've fallen behind in your bills. Suddenly one day you have an epiphany. Wait a minute. I have money coming every month. Now, the money that comes in isn't enough to pay all my bills, but I can sell that because it is value. So you sell those leases. That's legal under Article 9. Similarly to a promissory note for a mortgage loan instrument, you can strip out that payment obligation, and they do. However, when you strip out the payment obligation and you sell it, for example, to Fannie Mae, Federal National Mortgage Association, that is all that is sold. They've stripped out this I promise to pay, and when they strip it out, again, it's been converted to a transferable record, which falls under 15 U.S.C. 7021A, which talks about transferable records. And when it's sold, that's all it is. It's an unsecured obligation. Now, as many of us know, very, 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 very seldom is Fannie Mae ever named as payee on the tangible promissory note. Fannie Mae is never named into public record. And yet, Fannie Mae claims to own the note and mortgage. The question that I ask, what note and mortgage are you talking about? Are we talking about the E-note and the E-mortgage? Or are we talking about the tangible note with the tangible mortgage contract, of which that mortgage or deed of trust would be an alternative means for collection of payment should there be a default on the intangible payment obligation? You don't really know because everything is very, very vague. What they purport to do is once they strip out this intangible payment obligation, they send a notice to MERS. Every time this intangible payment obligation or these servicing rights are sold, they let MERS know, Mortgage Electronic Registration. MERS is a database. MERS is a registry, national registry. That's it. It's a book entry system. It's an electronic agent. What they purport to do years later upon default is do an assignment to the servicer if you were with the GSE. However, that assignment, many times, many people have a misunderstanding of what the role of an assignment is. The role of the assignment is to memorialize the sale of the tangible promissory note. It does not cause the sale. Again, it does not cause the sale. So the purpose is to create an audit trail showing that party A assigned to party B the note or the mortgage or the deed of trust that was to be attached to the said note obligation. The problem is that, for example, in 2005, I'll use me. My mortgage loan instrument was stripped and an interest of the mortgage loan instrument was sold to Fannie Mae. So, with Fannie Mae being listed and not being listed into public record, with Fannie Mae not being listed as payee on a tangible promissory note, because mind you, I was in bankruptcy. Now, for myself, I listed on my summary of schedules for my assets, I listed this promissory note debt on Schedule F as in Frank, none secured, none priority. While the attorney that I had originally was screaming at me to put it on Schedule D as in dog, claiming it was secured, well, I did a check into public record. I did a UCC1 financing statement check with the Secretary of State. There was no creditor attached to my property. So now, even though a party is coming forth with a claim to be a creditor, pursuant to BK Rule 3001, subsection D as in dog, which is under proof of claim, any party coming forth with a claim of a security interest must be evidenced by a properly perfected lien. So, again, how does one properly perfect a lien? Well, Levita, if you're in Cook County, I would have to go to the Cook County Recorder's Office and record this. If you are not named into public record, if you are not named as payee on the tangible promissory note, then how in the heck are you coming forth claiming to be a creditor? That's fraud upon the court. Now, Fannie Mae may have purchased an obligation, but there is an invisible line that divides Fannie Mae from the homeowner and the homeowner from Fannie Mae. So you have the tangible obligor and the tangible obligee. However, this tangible obligee wears many hats. That tangible obligee puts on a hat becoming the intangible obligor, who then sells this payment stream that was attached to the tangible promissory note in this instance to Fannie Mae. Fannie Mae becomes the intangible obligee or obligor. Fannie Mae then takes this payment obligation, pools it with about 1,000 other mortgage loan instrument interest, and sells it to 2005-062 Trust, where all of these certificate holders that have purchased an interest in these certificates are thinking that these are mortgage-backed securities. When in fact, Fannie Mae is not listed in public record. Fannie Mae is not listed on the payee line of the tangible promissory note. And don't let the title GSE fool you. Government-sponsored enterprise is just a name. Fannie Mae is a publicly traded company with board members. Their goal is to create a profit for their shareholders, period. So these infographics are very well. Section 3, we're getting into the mortgage fraud investigation, where we're talking about the analysis. I'm talking about what did I find. In this particular instance, where I researched for John Doe, and I found this in multiple classes of Fannie Mae 2007-029. So it is within this part of the educational package that I'm going through, and I give you my results, my opinions, my conclusions. So the reason I am giving them to you is for your educational purposes. In this particular one, I'm citing 15 U.S.C. Chapter 41, 1641G, Notice of New Creditor. I also cite 15 U.S.C. 7003, which states that UE, ETA, and e-sign do not apply to Articles 3 or Article 9. So this whole part where they're purporting to use electronic documents, well, unfortunately, e-sign and UE, ETA do not apply. They do not apply. So we go through the analysis again. I have statutes. I have arguments. This is a screenshot of the voluntary lien report. So in this instance, I'm talking about a particular assignment for this deed of trust. In here, I've got the record number, the recording date. So I'm giving you all of the information for this particular deed of trust, this particular assignment. If I was more than one assignment, then you would have this broken down into, again, more than one section. If you have an NOD or an SOT, again, I would include that depending on your state. If you're a judicial state, you are not going to have a notice of default, or you are not going to have a substitution of trustee. So depending on the documentation that I have will determine the arguments that I have. The more documentation you can give me, the better we are going to be able to articulate our arguments within the analysis, what was to happen, what did happen, what did not happen. If I have a copy of the note as it exists at the time of the action, being either in a civil complaint and summons or a copy of the note that was gotten through the use of a debt validation letter, then we are able to get into negotiability. What was acquired? Because there is only one statute pertaining to acquiring rights of negotiable instruments, we go there. Opposing counsel must go there. If you know what questions are going to be asked, if you know the answers before they're asked, you are that much better ahead. So this analysis gives you the information. So whether it be for MERS, whether we're talking about UE, ETA, or e-sign pursuant to 15 U.S.C. 7003, or if we're talking about 18 USC chapter 47, 1021, where we're talking about fraud. That is how you use this document. You are going to glean all of the information where you have an understanding. You will be the expert, being the attorney, being the pro se litigant. When you're going to have the statutes for you, when you understand them and you are in front of the court and you say, Your Honor, yes, we have a copy of the tangible mortgage loan instrument being a promissory note. And no, that is not a bearer instrument as opposing counsel claims. Opposing counsel does not know what a bearer instrument is. Your Honor, opposing counsel claims that is a blank endorsement. It is obvious he has not looked up pursuant to Illinois Commercial Code 3205 under blank endorsement, or 3204 for the definition of endorsement, meaning a signature alone. When you have this understanding of what happened to your particular loan at that instant for you or for your client, that is what makes this so strong. When you understand that we have case law out there, recent case law regarding that the homeowners have the ability to dispute assignments. Many times, opposing counsel states to the judge, Your Honor, John Doe here is claiming that this is a fraudulent assignment. John Doe doesn't have any right to make for such claim. He was not a party to this assignment. We have case law that came out in Casa J versus MERS, in which the courts had determined that the homeowners do have standing to challenge, because if the homeowner were to be injured, this issue would have to be redressed. So the whole point of understanding what is in this particular analysis and mortgage fraud investigation is to understand the statutes, understand the cases. Because when you're at 30,000 feet and you're looking down and you're saying, okay, this applied to me, this applied to me, this applied to me. It's not hearsay from the attorney. It's not hearsay from the homeowner if the homeowner comes to these conclusions. I understand many times in the past, opposing counsel would say, Your Honor, I object that affidavit of Joe Esquivel is hearsay. He has no firsthand knowledge. He is giving conclusion of law. He is leading the court into making a decision. Okay, fine. If the homeowner were to come to the same conclusion that Joe Esquivel did, and the homeowner properly presented it, or the attorneys presented it as their information, as they are the legal experts for that particular instance, the courts cannot stop that. The affidavit of fact that also comes with this product is just that. It is a factual affidavit. There are no statutes. There are no conclusions. There are no opinions. I state what I looked at. I state what I saw or what I did not see. Period. It is a true and accurate factual affidavit. When you understand how to actually use this information, this becomes a very, very large bullet, because it gives you the understanding that you can go forth and articulate, or the attorney can go forth and articulate. It's an educational piece. These particular statutes were used within the analysis. I also have gone through, and I have examples in which I've shown what is a blank endorsement. This is a blank endorsement, Joseph Esquivel. It consists of a signature alone. What is a special endorsement? A special endorsement goes to specific instructions. Pay to the order of Joseph R. Esquivel. What is a restrictive endorsement? An example would be for deposit only. I'm restricting the use of this particular item. If this were to be true bearer paper, it would state paid to the order of bearer. B-E-A-R-E-R. So when the opposing counsel says, Your Honor, I have bearer instrument. Wait a minute. Does it say paid to the order of with an as of yet unnamed payee? Yes, it does. Well, until that payee is named, it cannot be a bearer instrument. It must be completely filled in. If we go to Uniform Commercial Code, Article 3, Statute 203, D as in dog, or number 4, or if in New York, it's going to fall under UCC 1961-3202. However, the verbiage is very similar where it states, if the transfer purports to transfer less than the entire instrument, negotiation does not occur. The transferee obtains no rights under this article and has only the rights of a partial assignee. Well, if they are not named to the tangible promissory note on the payee line, that is one part of the mortgage loan instrument. If they are not named into public record, that pertains to the security instrument. That is part 2 of the mortgage loan instrument. And if they are not the sole party with sole claim to the sole interest of the general intangible obligation, which is the third part, they cannot lay claim to be P, person entitled to enforce. There can be no holder in due course at that instant. They have only a partial claim with a partial cause of action. This is how you use this document. This is how you use this particular mortgage fraud analysis and chain of title analysis. You become the expert. I'm going to take a few minutes and we're going to go into a particular case that came out. And this is a case, I'm not sure if you can see it on your screen. Let's see. All right, it's Eloisa, Eloisa Kasajay versus MERS. All right, this is a case in which the courts said and adjudicated that the homeowner did have standing. The court denied the defendant's motion to dismiss, the banks. And they find that Mrs. Kasajay has standing to bring this lawsuit against the defendants. This is a very important case. If anyone would like this case, send me an email to info@mortgagecomplianceinvestigators.com and I will send you this memorandum in order. Again, this is very important and I can't stress enough, this is one that you should read. Again, They cite, in this particular order, 2 other cases where the homeowner has standing to file an objection to the assignment that was put into public. I've also have it in an outline form. Where I've already gone through all the pages and you can read this again. If you send me an email, we will go through this. So the basic premise to this was that should the assignments not get challenged, that the homeowner would have an injury that would have to be readdressed at another time. So by the courts allowing the homeowner to attack the validity of an improper assignment, this is a big, big deal. Now, what I'd like to do is take a few minutes and show you what is going to go on in the upcoming weeks. In the upcoming weeks, I am putting together a set of classes. These classes are going to be 2 5-hour classes, 4 hours of teaching, and then 1 hour of Q&A after the class. We are going to cover everything from the front to the back in order to give you a complete understanding of what was to take place, what did take place. We need to go back into time. If anyone pays attention to the cases that the SEC files or the Attorney General of the United States files, they go back to basics. They go back to the Security Act of 1933 and 1934. When the Security Exchange Commission files a complaint against a particular bank, and that's been happening more and more, they go back to the same acts. When you understand what the Security Act of 1933 was, why did it come about? How does IRS play a role? These classes are going to give you an understanding that you need to know. You're going to need to have an understanding. What is a prospectus supplement? What is a pooling and servicing agreement? How does it pertain to me? How do I use it? How do I use it to educate my clients? What is MERS? That is an elephant alone that must be tackled, and that all parties need to have a thorough understanding of what MERS is and what MERS is not. You need to understand what is an electronic agent. What are negotiable instruments? What is bearer paper? What is order paper? So we will have PowerPoint presentations. We will have Prezi presentations. You will have live camera with me on a whiteboard. You need to understand what is fraud. Many people claim fraud in their complaints, but it stops there. They don't claim all 5 elements of fraud. And if you're going to claim fraud, you need to claim all 5 elements. We get into the 5 elements of fraud. If you don't claim all 5 elements, it will get thrown out. Day 2, we're going over documents. We're going to go over assignments, NODs, notice of default, substitution of trustee. We're going to go over this very important maxim in law, nemo dat quod non habet. Basically, it states one cannot sell what one does not own. However, this is done thousands of times every single day. So when you understand what is nemo dat, how does it apply to me? We're going to get into acquiring rights pursuant to your state-specific statutes. Because I understand when you are in a state court, they want to hear state statutes, state citations. You will learn how to read your state-specific statutes. We're getting to negotiation delivery, perfection of security interest. We've got a lot of good material that you need to have an understanding of, and you need to have a complete understanding. You need to understand, who is Pete? Is Pete involved with my mortgage loan instrument? We're going to get into consequences. We have a number of things that happen when you don't take an action or you take an action. So I've got a list of about 10 or 11 different consequences that happen should you decide to take an action or decide to not take an action. We're going to get into Federal Rules of Civil Procedure, the 12B6 and 12H3. Many of you may already be familiar. Again, this is an area of which we all need to have a better understanding. Many times we have a case that is in a state court. It gets remanded to federal court. 7 or 10 days later, there's a motion to dismiss. Before you know it, you've got a 12B6 dismissal. And the party is left standing with not knowing, what do I do? How did I get here? The 12B6 is given because many times when these state cases are remanded to federal, there was no federal cause of action. So they need to petition the court to amend the complaint, petition the court for reconsideration. Or you need to have a federal complaint with a federal cause of action. And while many disagree with me, while I say that wrongful foreclosure is not a cause of action, theft of real property is a cause of action. Fraud is a cause of action. Now, one of the things you can ask yourself is, did the court have subject matter of jurisdiction? Did the court have the jurisdiction to make whatever ruling that they did, for example, for summary judgment? If the court did not have jurisdiction to make the ruling, then you can get into the 12H3 rule. Because the courts did not have subject matter jurisdiction prerequisite, the case may be ripe for dismissal. We're going to get into elements necessary for summary judgment. We're going to get into how to void the summary judgment. What do I need to show to file a motion to vacate summary judgment? Are there genuine issues of fact? We're going to get into depth on the RMBS infographics. We're going to go into a lot more explanation. So this is a lot more information that isn't even attached to this day 1 and day 2. So these are the basics that we will be getting into for the online training. I would highly recommend that everyone that is online today sign up for the course. If you want to have a full and comprehensive understanding of what I'm talking about, so that when you're in front of the judge, you can articulate correctly the arguments, so you know what it is you're talking about. So when someone holds up a document that says, I have the true and correct copy of the note, Your Honor, I got the authority to foreclose. And yet upon examination of the note, you find that they are not named to the note. You realize that document is no longer eligible for negotiation because an interest of that mortgage loan instrument was sold 10 years ago to Seawalt 2003 Trust. So with an interest of that mortgage loan instrument being sold 10 years ago, with the note having an as of yet unnamed payee, and with the party standing in front of the court not being named into public record in a timely fashion, and again, the word timely fashion, just because you are named into public record doesn't make it legal. It may not be lawful. The whole purpose of what is being filed into public record on the part of the servicer and the foreclosing entities is to purport to create a fake audit trail so the courts can look at it and say to the judge, Your Honor, look at us. We've acquired the mortgage. Your Honor, we have a copy of the note. Well, upon further examination, you find out that it's fraud upon the court because what was purported to be and what actually is are different things. This is what an education will give you. It will give you the knowledge to go forth and take action. Because just learning this information does you no good. You need to apply the information correctly. If you go to a gunfight with a knife, you're going to get your butt kicked. And that's how we're getting all of this bad case law. We have Mers versus Edelson, for example, out of Nevada. The attorneys did not articulate the correct arguments. They did not have an understanding. They did not want an understanding. They just wanted the homeowner's money. If the arguments are kept short and brief and accurate, I believe that the judges will take notice. The whole purpose of the district court is to come to a finding and by statutes. The district courts rule by statutes. The appellate court rules on procedures. Did the district court rule correctly in its finding? Were their procedures correct? Did they have matter of subject jurisdiction? Yes or no? Many times the courts did not have the jurisdiction to make forth the proper findings. Many times the incomplete arguments caused a bad ruling on the part of the courts. I've seen many cases where the parties that were making an argument made what they had thought they were saying was not what was being said on paper. And the judge told them, listen, I understand what you're trying to say, but that's not what you said. I think I know what you're trying to say, but I'm not sure. I have to rule based on what you are putting in the pleadings, based on what your oral arguments are, based on the statutes which you are presenting. Because if we put forth bad arguments, we're going to get bad case law. And it is this bad case law that we need to overcome. Because opposing counsel is going to cite case after case after case. And what we're going to have to do is to stress to the courts and articulate to the courts with specificity and particularity that we are arguing upon the merits of the legal theory of the statutory requirements of law that were set forth by the legislative body of that state. That argument that the opposing counsel is giving is based on a different set of arguments. They are not going to articulate what you are saying. They will not have an understanding as to what you are saying. When you can articulate your argument in detail with specifics, the judges will listen. I have been in court 9 times. 9 times I walked out smiling. Yes, I've discharged a debt on my tangible promissory note, going on 3 years now. So I have walked in the shoes of many of you out there. The only remedy is through the judicial process that I see. My job is to arm you with the proper bullets that you have that will bring resolution. My goal is not to give anyone a free and clear house. My job is to provide an analysis of what was to take place, what did take place, and what did not take place. And armed with this information, you can go forth and adjudicate a proper resolution. A win comes in forth of many different ways. So depending on your particular situation, a win for one party will be a different win for someone else. I have seen default judgments get reversed. I have seen trustee sales get reversed. Default judgments get reversed. It does happen. I've got plenty of clients that it has happened to. I've seen principal reductions. I've been there in person when opposing counsel wanted to do a principal reduction because they did not want their dirty laundry out into the